Good afternoon, everyone. My name is Shauna Marshall, and along with Alina Ball, I co-direct the Center for Racial and Economic Justice at UC Hastings College of the Law. We are one of the sponsors of this event. Before we begin today's program, I want to start with a land acknowledgement statement. The Center for Racial and Economic Justice recognizes that UC Hastings land is located in Yelamu on the ancestral land and unceded land of the Ramaytush Ohlone people. This land was and continues to be of great importance to the Ohlone people, and we embrace their continued connection to this land. We offer this land acknowledgement to build mindfulness of our present participation in colonial legacies, and we affirm our commitment to hold UC Hastings Law School accountable for its impact on American Indian and Indigenous peoples. Let us now take a moment of silence to pay respect to Ramaytush Ohlone elders and to all Ohlone people, past and present. Thank you. First, besides welcoming you, I want to thank all the many sponsors who made this discussion possible. Let me list and acknowledge them now. The Asian American Bar Association of Northern California, the California Lawyers Association, the Charles Houston Bar Association, Chinese for Affirmative Action, the Center on Law, Equality, and Race at UC Irvine, the Critical Race Studies program at UCLA Law School, the Dolan Law Firm, the Equal Justice Society, the Filipino Bar Association of Northern California, the Mexican American Legal Defense and Educational Fund, Repair, and the UC Berkeley's Asian American Studies program. We are incredibly lucky to have what I would call a superstar panel who will lead a provoking discussion on affirmative action just 1 month before California votes on Proposition 16, which would reinstate affirmative action. Sadly, this country has literally whitewashed its history. We really do not study, critique, or understand the white supremacist system put in place by the colonizers. We either sugarcoat or skim lightly over our history of slavery and Jim Crow, over the genocide of Native peoples and the theft of their land, over the Chinese Exclusion Act, the alien land laws, the Japanese internment, over the land claim courts that stole Mexican land when we fought in that unjust war, or the Bracero program, or the lasting inequities of our GI Bill, and on and on and on. All that pretense allows us to avoid real reparations. And that's what affirmative action is. It is just one very small piece of the reparations owed marginalized and colonized people. Today, this superstar panel will discuss this dilemma, and I will be very brief in their introductions as they are known to almost everyone in this audience. Our panel will be moderated by Vinay Harpalani, a professor at the University of New Mexico School of Law, who is a renowned scholar of affirmative action and has written many articles on this topic. Our panelists in alphabetical order are César Cruz, author of Revenge of the Illegal Alien. Dr. Cruz is a grassroots community activist who participated in 1995 as a student in the hunger strike when Proposition 209 eliminated affirmative action. We also have with us Cheryl Harris, the Rosalinde and Arthur Gilbert Professor of Civil Rights and Civil Liberties at UCLA Law School. Joining us is also Jerry Kong, Distinguished Professor of Law and Asian American Studies, and Founding Vice Chancellor for Equity, Diversity, and Inclusion at UCLA. We are lucky to have Iva Patterson, President and Founder of the Equal Justice Society, and one of the chairpersons on the Yes on 16 campaign in California. She is a civil rights guru, one of my sheroes, and my BFF. And last but not least, we have Tom Sines, President and General Counsel of the Mexican American Legal Defense and Educational Fund, and also a chairperson of the Yes on 16 campaign. Tom is truly one of the most scholarly and active civil rights attorneys of our era. So with that, I will turn it over to Professor Harpalani, and we all look forward to this wonderful discussion, and again, a warm welcome.
Thank you, Shauna. It's just wonderful to be part of this all-star panel, and I'm really looking forward to it. I'll just say a few logistical things before we get right into the panel. The order of panelists, Iva Patterson will speak first, followed by Jerry Kong, César Cruz, Tom Sines, and then Cheryl Harris will speak at the end. I'll ask each panelist to keep your remarks to about 7 to 10 minutes. After that, I will moderate a discussion where you can say anything else that you might have not been able to say in your remarks. And once the panelist is done, you may transition directly into the next panelist. There's no need for me to say anything in between panelists, just so we maximize the time for discussion. So with that, I'll turn it over to Iva Patterson.
Good afternoon. It's an incredible honor to be part of this panel of warrior activist scholars. And Shauna, thank you for inviting me to this. I think it's very unfair that I can only speak for 10 minutes because, as I've often said to people, I'm a magna cum laude graduate of the Fidel Castro School of Public Speaking, and I have a lot to say, but I'm not going to wear out my welcome here. I'm so glad that Shauna started off talking about colonizers because I wanted to talk about when affirmative action started. And when I first started thinking about this, I thought that the school desegregation cases were the first time that race was used in a positive way in policy or law. But Ron Ellis, who is, and I think was and maybe still is, a magistrate in New York, said, no, the first time this was done was really right after the Civil War when the Freedmen's Bureau was set up. There was a notion that the formerly enslaved people needed to be made whole, a form of reparations. So that's when this started. Then you fast forward a century and you actually find that there's an African-American member of Richard Nixon's Labor Department who is looking at the awarding of government contracts and is seeing that businesses owned by people of color are not really being given these contracts. So actually out of Nixon's administration, you've got one of the first examples of race-conscious contracting. That is codified in Executive Order 11246 in the Johnson administration. You then have, when I start, entering the picture, when people from my era, the OGs, started entering the picture. We were taking over buildings. We were making sure that the student bodies of various educational institutions had lots of Latinos, Asian Americans, Native Americans, and African Americans, and women as well. So this is rolling along. You've also got a lot of litigation that talks about the underrepresentation of people of color and women in various departments. Shauna, Tom at MALDEF, and Ed Lee, when he was still alive and at the Asian Law Caucus, we sued the San Francisco Fire Department because there were no Asian American officers in the department. Black people were being suppressed, Asian Americans, Latinos, all the groups, and women couldn't even apply. So you started seeing goals and timetables implemented in various public entities. There was Supreme Court law that said you could do this without being sued. And so people around the country were seeing various agencies, educational institutions, and contracting schemes transformed by race and gender conscious contracting. So things are going well. Meanwhile, back on the East Coast, there's a group called the National Association of Scholars. I was doing some research, trying to be a scholar, before this event, and was trying to figure out if what I had heard anecdotally could be verified. But what I heard is that in some institutions, people were making a push to have the faculty makeup reflect the racial and ethnic makeup of the student body. And many of the professors went, oh my God, that means I'm going to be out of a job. Now we move back to the West Coast. There are two academics, Glenn Custard and Tom Wood, one of whom felt he was passed over for promotion because a woman or person of color got the position. So they started writing something that ultimately became Proposition 209. Now we move to the Republican Party, which never misses an opportunity to use race in a destructive way to advance their own agenda. Pete Wilson had done this very well in the anti-immigrant move, Proposition 187, and he thought, ooh, I can do this again. I got to be governor using that. Maybe I can become president. You also have in 1992, Bill Clinton defeating George H.W. Bush for the presidency. And the Republicans said, oh my God, one of the reasons this happened is because California's electoral votes went to Clinton. So Patrick Buchanan, and some of you are too young to know this guy, but he was a speechwriter for Nixon, and it's all of a piece. He wrote this column in 1993 saying, the only way we can get California's electoral votes back, he called it the crown jewel of electoral votes, is to have something on the ballot that will activate and mobilize what was then known as the angry black men. They became the Tea Party. They're now MAGA. They never seem to go away. They decided, once again, let's use race as a wedge. That always works for us. So they decided they'd put something on the ballot that activated people's racist views. So they picked the repeal of affirmative action. And at the time, if you looked at polls, Californians didn't care about affirmative action. They were more concerned with housing, health, their kids. Affirmative action was not anything that was that important to them. So I just got the hook and I have 5 minutes. So I'm going to power through 24 years in 5 minutes. They put this on the ballot. It was brilliantly, although other black folks I talked to say, don't say brilliant, say it was devious. They had the language of the 1964 Civil Rights Act. It was called the Civil Rights Initiative. Many people thought they were voting for civil rights and didn't know they were taking civil rights away. So we lost. I can tell you a whole story about what happened, but I do not have time. So starting in 2008, we started doing polling to see if the electorate in California had changed enough so that people would be willing to repeal Proposition 209. The first 5 polls we did, no, 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 no. We did a poll last summer that indicated that while we start below 50% in terms of approval rate, once you explain to people that that the repeal of 209 reinstates affirmative action, levels the playing field, people come to our side and we get to 53%. We went to Dr. Shirley Weber from San Diego. She carried this bill. The Black Caucus unanimously was for this. Then, and Jerry may talk about this, the Asian American Caucus was very leery about this because there had been some very ugly things that had gone on where they were unjustifiably attacked a few years before for trying to get rid of, trying to reinstate affirmative action at the colleges. So the AAPI caucus said, wait. I was like, no, we can't wait. So then we waited. So fast forward to the beginning of the year, the progressive Democrats are going, please don't have this on the ballot before the primaries come. I'm going, grrr. So it was introduced on March 10th. 3 days later, most of the state went on lockdown. Two things happened that totally transformed this debate. COVID-19, or as some people call it, COVID-16-19, showed that even a virus is racist. We see who's disproportionately being stricken with this disease. We see who the essential workers are who have to go out and expose themselves. So people saw this was a problem. This got us out of the assembly. Then the death of Mr. George Floyd made Americans had to stop saying, I don't see color. We're post-racial. We had a black president. What are you talking about? The whole nation saw that racism was alive and well. So we needed a 2/3 vote to get out of both houses of the legislature. We got 75% of both houses. That put Proposition 16 on the ballot. Really quickly, there's a problem from our perspective that we think we can overcome. Many people don't know about Proposition 16. The ballot is so crowded. People are more concerned about COVID, the insane president, and the like. And so propositions are not top of mind. They also sometimes get confused when they read the language. We have done polling and focus groups that indicate that once you explain to people what this is all about, things quickly change. We did a test on a TV ad, and the percentage of people who changed their mind in our way for one group was 19 points. People jumped 19 points. So our goal is to get the word out. If there's anybody out there sitting on a trust fund who feels guilty because they have $1 million, call me. I have a good use for your funds. People are voting right now. Those of you who think affirmative action is important, please contact all your friends, get yard signs. You can go to voteyesonprop16.org. We've got masks and everything else for you. I'm actually going to be done a minute early, and so I will turn it over to Jerry Collin. Thank you very much.
It's a pleasure to follow up on, Ava. Hey, my focus is to talk to the undecided voter, especially if you are an undecided Asian American voter. I want to say 4 things. Number 1, discrimination against Asian Americans is it's a real thing. It happens. Like you, I'm kind of tired of being told that we're constantly the model minority and only good things happen to us because of race. I'm not just talking about the idiots who are saying racist things because of COVID-19. I'm talking about genuine worse treatment in the workplace, in environments and contracting. Now, whenever anyone says, oh, someone is being treated worse, it is important to always ask, as compared to what or as compared to whom? And I want to use the treatment of white folks as the gold standard. If we're talking about race discrimination, I think it's really useful to compare how you're treated compared to white folks. And I think the best evidence suggests, whether you're using statistical regressions or a lot of the work that I do on implicit biases, that Asian Americans do suffer some discrimination. Now, this is the true opposite of affirmative action. It's what I call negative action. Asian folks are treated worse than white folks. That's who the real beneficiaries are, and this has been happening all along, even under Proposition 209. If you don't like it, the answer is simple. Stop treating white folks better than Asian folks. I don't think anyone's arguing against that. That's number 1. Number 2, discrimination against other racial minority groups is also real. It's definitely a thing. If there's discrimination against Asian folks, you think there isn't discrimination against, like, our fellow Black and Latinx and Native American brothers and sisters? Of course it exists. It's explicit, it's implicit, it's structural, a certain kind of perpetual motion machine of how racial hierarchy persists. You know it. If you didn't know it, you certainly know it now when we are asking the hard question, do Black lives actually matter in America, and can we be held to account? And I'm applying the same standard, right? I'm using the treatment of white folks as the gold standard. And if you ask, hey, are Black people treated worse than white people? I think you're going to have to say yes. That's not right. We want to give every single individual, regardless of race, a fair shot at winning at America's tournament. But here's the hard part. Whether any individual has that fair shot turns on the environment in which the person is actually learning and working. If you are marinating in a toxic environment, in a workplace or in a college campus, and there's no one who looks like you, right? You don't have a critical mass. There's just lots of social science evidence that says it just makes it harder for you to succeed, to be as great as you can be. Our fates are linked in that way. Number 3, Proposition 16 gives us the tools to create that more equal learning and working environment. So let's just stay focused on this thing I call critical mass. The general point is just, if there are very few people like you, then the first time you kind of screw up, you kind of look around and say, look, there's no one who looks like me doing this. Maybe it's not for my people. Maybe I should find some way to exit. It's just harder to be excellent, depending on your merits, if there's no one who looks like you doing that kind of work. Now, for some groups, there will already be enough people such that each individual has that fair shot. So like if a white guy can't make it into the corporate boardroom, it would be odd for the white guy to say, well, it's because I'm a white man. That's why I can't make it in the corporate boardroom. You might say the same thing for women in an English PhD program. You might say the exact same thing for East Asian males like me in an engineering program. It is unnecessary to include these folks into affirmative action programs when there's already enough of us such that we have a critical mass and every individual can succeed or fail on her merits. But some groups lack a critical mass. I mean, think about women in senior management. Think about, I don't know, Filipinas in physics. Think about East Asians in poetry. Is it possible that their being who they are and the stereotypes that exist about those people actually undermine their performance and do not give them a fair shot? I think the answer is yes. Look, there's no easy right or wrong answer. The work has to be done extremely carefully, as federal law currently requires. And I think my colleague, Professor Harris, will actually explain in greater detail. It has to be a compelling interest, narrowly tailored. It's super hard to do that work really carefully under federal law, but that work should be done. And we, as people who care about our institutions, should be able to do that hard work without like artificial, constraints, which is what Proposition 209 puts upon us. Fourth and final point. Proposition 16 does not discriminate against Asian Americans. Remember my definition. Discrimination, whenever anyone talks about it, you got to always ask, as compared to what? I'm saying as compared to white folks. Discrimination means worse treatment than white folks, what I've always called negative action. Look, not being included in affirmative action and being treated exactly the same as white folks is not racial discrimination. It's being treated exactly the same as them. It's neutral. It's neutral action. My general point is, look, if we as a society don't need it, we won't use it. Our outrage, Asian American outrage, is outrage against white people being treated better than us for no reason. Notwithstanding all that history, notwithstanding all that disrespect, notwithstanding all the nonsense, when white people are treated better than Asian people, of course we're going to get pissed off. How could it not be otherwise? Like, what's the argument in favor of that on the basis of justice? Our outrage is not against considering race and gender as one of many different factors to make sure that everyone has a fair shot, including some of us, depending on the context. Don't get confused between the two, and that's how you will avoid getting played. All of this is hard, and I realize that we won't all agree. We shouldn't all agree, but at least we can have honest conversations about how to think about these complex concepts. And as I joke, don't get played. The final thing I'll say in my conclusion is, look, Asian Americans are just kind of a weird minority group. We're oftentimes called the model minority or the middleman minority. We're in this kind of liminal space between white folks and other people of color. We could identify as honorary whites and try to pass into privilege, or we could actually identify as people of color. I know there's a bunch of pushes and pulls, and if people don't want us, it's hard to feel like we should throw ourselves and lean in one direction, but there's always a choice. There's always a choice. And I'm trying to say, if our choice is about racial justice, if our choice is about just basic fairness, right? Even if you don't feel guilty about stuff that happened in the past because you didn't do it or you're a recent immigrant, if you just care about giving, say, your daughter a fair shot, about giving yourself a fair shot if you're stuck in middle management and can't go up higher. If you just want a fair shot, then people of goodwill have to design that environment accordingly. And that environment can only be built if we have all the tools. Voting yes on Proposition 16 gives us those important tools. And that's how we can get to a better place tomorrow.
Thank you so much, Jerry. Thank you so much, Iva. It is my honor to be here with all of you. Many blessings. My name is Dr. César Cruz. I want to ask your permission to speak in particular amongst legal giants in the field. Shout out to these legal scholars, to these legal activists, and to the rebel lawyers on this panel. And to all of you amazing folks that have put this together and that are tuned in. We truly welcome your thoughts and your questions on the chat. So please, please chime in. I have to confess, I'm not a lawyer, far from it. I am a proud community activist, and I come to this conversation thanks to the invitation of Beth Ribbett from Repeal. In 1994, 2 years before the passage of Prop 209, the University of California Board of Regents were discussing the idea of ending affirmative action. I was 21 years old at the time and a student organizer on the campus of UC Irvine. 1 year later, the UC Board of Regents, under the direction of Ward Connerly, effectively ended affirmative action, and we felt it was necessary to stand up for our rights. And we had to do more than just rally, to do another teach-in or another march. We decided to ultimately put our bodies on the line and to go on a hunger strike. Imagine going 16 days without eating. We went on a hunger strike and went 13 days on the UC Irvine campus, but then we were arrested for merely exercising our First Amendment rights. But we continued with our hunger strike in prison, and thanks to the people, we were released a day and a half later. Then we were flown to the state capitol to try and meet with then Governor Pete Wilson as we continued our fast that ultimately lasted 16 days. Although we weren't victorious in changing the law, this spawned a wave of activism that now 25 years later has never wavered. The ending of affirmative action was never a stop to so-called reverse racism. It was never what Bakke, Connerly, or others claimed. Ending affirmative action only makes sense when equity creates the conditions for what society likes to call a level playing field. However, what this pandemic has highlighted are all of the disparities affecting people of color and the poor. Black and brown folks, indigenous folks, Southeast Asians, Pacific Islanders, and the poor have been the heaviest hit by job loss, by COVID-19, or as Iva aptly named it, COVID-16-19, and to access to resources and real support. We now have created curbside communities everywhere with people who are without basics, including running water or a sustainable roof over their head, who are living on the margins of society. How can we be okay with that? How do we remedy that? Affirmative action seeks to be a remedy for a legacy built on white supremacy, patriarchy, and capitalism that has always privileged rich white men with property, that has created the following conditions. Did you know that 39% of the population of California are Latinos, but they are not mirrored in institutions of higher education or even land ownership? We are 44% of the prison population, with over 56,000 of our people locked up in cages. 90% of them have plea bargained with little to no representation. We have forgotten that it is Latinos that helped to desegregate California's schools in the 1930s with the famous Lemon Grove case, and then the landmark case Mendez versus Westminster in the 1940s. If California is indeed a brown state and Latinos desegregated public schools in California, why are brown folks overly represented in prison and not in college? How is that not white supremacy by design? Affirmative action has never been about privilege or reverse racism, but it has been a remedy towards white privilege that for 200 plus years in these institutions and for over 400 years in the history of conquest in this nation created institutions only for rich white men. And then when affirmative action passed, it truly benefited mostly white women in record numbers. Affirmative action is just not colorblind. It sees race. The old colorblind argument of the 1980s doesn't acknowledge or see us. What the Black Lives Matter movement has resurfaced to our society is how race, and in particular racism, is such a cancer in our society and must be removed in order for us to breathe. The BLM movement is saying what the Black Panthers, the Brown Berets, the I War Quinn, and the Young Lords were saying 50 years ago. We must remember that slavery was abolished except as a punishment for a crime. So if you can create the conditions to perpetually criminalize people of color and the poor, you will forever have slaves under the 13th Amendment. That is why we have prisons filled with Black and brown bodies, and we don't see that mirrored on any California college campus. Black and brown lives do matter. They matter as prisoners, as slaves, as sold off indentured servants on the stock markets for private prison corporations. That is the legacy of white supremacy today, of legalized slavery, and affirmative action seeks to start the process to remedy that. Under affirmative action, no person of color or white woman is admitted merely for the color of their skin. It is one of many factors, including test scores, essays, GPA applications, letters of recommendation, and so much more. It is just one factor, and a deeply necessary one, because as we have been colorblind, or at least we said we were and are, we have created color-filled prisons by design with crack and powder cocaine laws that unjustly discriminate against people of color. And in our college campuses, we have privileged white bodies, rich bodies, where we have always been able to buy a seat at the table on any college campus as long as our skin is white and our green can afford us to do so. We oftentimes say that Asian Americans are having success in college, but this glosses over the fact that Southeast Asians and Pacific Islander communities are oftentimes swept under this very old and tired model minority rug and forgotten. It ignores the Harvard lawsuit and that Asians are being discriminated as well. 25 years ago, I was undocumented, paying taxes but unable to vote, fighting for affirmative action, fighting for reparations. 25 years later, I'm a U.S. resident, still paying taxes, still unable to vote, still fighting for reparations. It is hard to imagine that I, a Mexican citizen in ancestral Mexica land called California, where the constitution of this state is written in Spanish, where we didn't cross the border, but white supremacy crossed us, I am now made to be called a perpetual illegal alien on our own ancestral lands. Doesn't that merit reparations? It has gotten to the point that I, an educator with a Harvard doctorate, still can't vote in my own ancestral state. I'm still left on the back of the bus or not on the bus at all when we talk about race and we only say black and white. How do we remedy that? How do we stop calling Mexicans perpetual foreigners in their own ancestral land when reparations for a brown majority are way overdue? In these elections, technically, I'm still not allowed to vote. However, I, like you, we vote with our voice, with our actions, with our calling, with our life's work. For the past 25 years, I've been an educator, the founder of Homies Empowerment, an organization whose mission is to ensure that brown and black bodies are seen as healers, as warriors, as scholars, and as hustlers too. When we say hustlers, we mean that we will always find a way out of no way. Now in Oakland, California, we are building our own institution of learning. We are building a high school from the ground up for youth who have been marginalized by white supremacy. That school is a part of the answer. Affirmative action and Prop 16 is a part of the remedy. And we have to stand up yet again, because no one will ever give us our rights based on the morality of our argument. We have a duty to fight, and as Sada Shakur instructs us, we have a duty to win. Our struggle now means passing Prop 16, fighting in the courtrooms, in the community, and in the streets. Our struggle against white supremacy for equity and reparation continues, and we will be victorious. Don't let the loud bark on the national level of white supremacy continue to fool you. Its time has come. That is why they are scared and trying to eliminate critical race theory. That is why our governor has vetoed ethnic studies. But that fight has been long coming. That victory is on the horizon. My people, will you vote every day, everywhere? And remember that the ancestors like Harriet Tubman are looking on. They have weathered many other storms, other viruses, other cancers. We will weather 2020. We will weather this one, and we will thrive. My people, the struggle continues. And I humbly say, all power to the people as I seize my time and I pass it to the Mexican American Legal Defense and Education Fund, Brother Tomas Sáenz. Thank you so much.
Thank you, Dr. Cruz. Before I begin, I have just one question for whoever decided I should follow Dr. Cruz, and that is, why do you hate me? But let me extend off of his eloquence to return to the era when I began as a civil rights lawyer at Maldev in 1993. This was an era of tremendous oppression and pressure on the Latino community because of the growth of that Latino community in the state of California. We are on the cusp of beginning a series of 3 ballot measures that more or less directly targeted the growth of the Latino community. As Iva already explained, the first of those measures was the now notorious Proposition 187, passed by voters in November of 1994. This was clearly a racial wedge issue seized upon by Governor Pete Wilson to drive his own reelection without regard to the harm that it would do to the unity of our state and to its growing Latino and Asian American populations. It was followed 2 years later by the proposition that would be repealed by Proposition 16. Proposition 209 was put on the ballot as a result of the efforts of Pete Wilson once more, but one of his appointees as well to the University of California Board of Regents, Ward Connerman. It was placed on the ballot once more as a racially divisive wedge issue designed to spark turnout among those in the white community who were afraid of demographic change in the state of California, and in particular afraid of the growth of the Latino community. 209 itself would be followed 2 years later by a measure placed on the ballot by another multimillionaire named Ron Unz, Proposition 227, that targeted the use of Spanish language and other non-English languages in our public schools. So Proposition 209 was squarely situated in an era of demographic fear and reaction to that fear through ballot measures designed to divide more than to unite. And true to its intent, Proposition 209 played out that way. The LA Times exit poll tells us that supermajorities of voters of color voted no on Proposition 209. Indeed, Latinos voted 76% no on 209. African Americans voted 74% no on 209. Asian American voters voted 61% no on 209. but the mismatch at the time between the population of the state and those who turned out to vote, or were eligible to vote, was such that 209 nonetheless was enacted with 55% of the total vote. Now that division should in and of itself be a troubling concern to all of us. It is a part of the background that this state has struggled with for nearly a quarter century, putting together the most diverse population in our nation in unity to move forward with a progressive agenda for the future. 209 has been a barrier to achieving that. But it's also true that in a quarter century, much else has changed. I pointed out that the Latino community that I represent had the highest no vote on Proposition 209. If anything, that suggests that we in the Latino community have a special responsibility to ensure that Proposition 16 removes this stain from our history and from our law books. We have both an opportunity and a challenge in the fact that Proposition 16 is the repeal of that divisive measure from 1996. Our challenge is we inherit the ambiguous and misleading wording of Proposition 209. Too many look at it, see that it says, "You shall not discriminate," and are concerned about removing those words from our state constitution. But we should have no such concerns, because the truth is those words were added specifically to mislead people to support Proposition 209. In fact, the words banning discrimination were wholly superfluous, because both the United States and the state constitution have prohibited discrimination on the basis of race or gender since the civil rights era. We did not need to add that prohibition. In fact, the true intent of 209 was simply to end any consideration of the most aggressive measures to address ongoing discriminatory disparities that we see in education, employment, and contract. We have an opportunity, however, in this repeal because much has changed in the quarter century since Proposition 209. From the perspective, again, of the Latino community, we are now not only 40% of the total population of the state, we are 27% of registered voters in the state of California. That means that we are more than 1 in 4 potential voters this November, and we have an opportunity by replicating the level of opposition to 209 and our support for Proposition 16 to drive the restoration of an opportunity to long-deprived policymakers and populace in California to consider and implement real, aggressive, and deep measures to root out the disparities that are so close at hand and transparent to all of us in the context of this pandemic and the unprecedented recession that it has precipitated. And in the context of, through the tremendous activism and nationwide demonstrations of Black Lives Matter, to demonstrate to all of us once more that systemic racism and injustice is real, that we have to act aggressively to root out the everyday and often deadly consequences of our ongoing failure to take policy steps to address and eliminate the disparities that we regularly see. And again, for my Latino community, I say, we have grown in population. And some, even within our own community, have been fooled by that demographic growth yielding progress, such as the headlines from a month or two ago, that we were now, for the first time, the largest racial ethnic group among those admitted to the University of California. Some looked at that headline and said, we don't need Proposition 16. But the truth is, we should have hit that milestone a decade or longer ago. Here are the facts today. Today in California, 54% of 12th graders in public schools in California are Latinos. 54%. Of high school seniors on the cusp of going on to higher education, are Latino. And yet, only 25% of all undergraduates in the University of California system today are Latino. That's a 29 percentage point gap. It's that kind of huge disparity that we as a society, to secure a thriving future for our state and all of us, must enable our policymakers to address with compassion, but with thoroughness, a thoroughness that we have been deprived of for 24 years. And that, to me, is the greatest damage done by Proposition 209. It's not that we could not implement race-conscious and gender-conscious programs. Yes, that's a harm. But the greater harm has been that it has prevented us from even discussing with seriousness and depth the disparities that we see and experience on a daily basis. It has prevented us from discussing and analyzing with deep thought and thorough consideration what can be done to address those disparities. As you will hear from Professor Harris, what else has changed in the last quarter century is the U.S. Supreme Court has made clear the careful thought and analysis that is required for any government entity in this state or throughout the nation to consider affirmative action. They must look deeply and analyze thoroughly at the disparities that exist, identify their causes, and search for solutions, beginning with race-neutral and gender-neutral solutions. We know in the end those are only partial solutions, but in this state, we have hamstrung ourselves and prevented even discussing such solutions because of the ban on affirmative action. There's no elected official anywhere in this country who wants to highlight an issue like these racial disparities when he or she knows that in the end they will be powerless to take the necessary steps to address the issue. The consequence is, by taking off the table affirmative action, we have prevented our most thoughtful policymakers from even considering and analyzing carefully what can be done to root out discriminatory disparities in education, employment, and contracting. This measure, above all, is about ensuring that we have all the tools for our policymakers working with those in the public whose most important role is to pressure them. But working together through 16, we can ensure that all of the tools are available to put in place to ensure equal opportunity for all in the state of California. I now turn to Professor Harris.
Thank you, Tom, and thanks to Alina, to Shauna, to all of the organizers, as well as to my fellow panelists. As somebody who arrived at UCLA Law School immediately in the wake of the passage of SP1 and SP2, the Regents' resolutions that were referred to before, they were the precursor to Proposition 209. I feel like my career at the University of California has really been shaped by this fight. In fact, the first day that I arrived on campus and showed up at my office, there were students sitting by the door organizing a resistance, some of the same ones that Cesar was referring to. And many of them have gone on to become leaders in the fight, as he has, in related racial justice struggles. So in many ways, Prop 209 was my introduction to some of the major policy battles that have continued to resonate in today's context, even as the conditions that we face and the forms of resistance have evolved. So in taking up the question of Proposition 16, I want to drill down a little bit more on a set of questions that I think are implicit and perhaps even ones that may be posed when we encounter people and are trying to talk about this issue and the reasons for, urgent reasons for adopting Proposition 16. As several speakers have alluded to, the federal constitutional framework for evaluating affirmative action is really quite hostile to these policies. It evaluates affirmative action as the equivalent of race-based segregation. The Supreme Court doctrinally disfavors these policies and requires that they pass through the highest level of constitutional review. A so-called compelling governmental interest is required, and they must pass through the eye of the needle, something called narrow tailoring. So one question is, why should we invest in trying to repeal Proposition 209 at the state level when the barriers at the federal level might still be a problem? Moreover, if we think about the recent passing of Justice Ginsburg, the possibility is that the court will shift even further, and that the 5 votes that permitted some forms of race-conscious affirmative action were no longer there. So one question we might ask is, why is this a fight worth fighting for? I think Tom has to some extent indicated that one of the reasons is that the state constriction under Proposition 209 closes the door even further, arguably, than the federal barrier does. But still, I think it's a fair question. One of the things, the way I think about it, is that the fight is about all of the things that people have talked about, but there is also a battle of ideas going on here. There's a battle of ideologies, the ideologies that structure our legal, political, and cultural systems. And contrary to some of the theories of legal interpretation that we are sometimes taught in law schools, the meaning of certain principles like equal protection of the law, like discrimination, are not self-evident. They're not self-evident either from the words themselves nor from the contested history, even though all of those things are relevant. So the question is, what is racial subordination? How do we define discrimination? And if we think for a moment briefly historically, we can see that we have lived under different regimes that have defined discrimination very differently. If we start with Plessy, which held that racial apartheid was in fact consistent with equality, did not constitute discrimination, we can see how Brown, which overruled Plessy, held that de jure segregation was discriminatory, did not comport with equal protection. But then post-Brown, we move into a period of contested and divided decisions in which the court said, well, neutral rules that operate to lock out historically disadvantaged groups and leave an unequal status quo, that those kinds of rules can be challenged as discriminatory. This is the case of Griggs, in which the court said that Title VII basically can attack neutral rules that lock in an unequal status quo. At the same time, however, shortly thereafter, the court said, well, if you're challenging those same rules under equal protection, you actually have to prove intent. So we have a kind of mismatch, a kind of contestation of ideas about what constitutes discrimination. The past several decades, however, have moved to install a particular vision of equal protection in which discrimination has been redefined. And now we have a kind of principle in which all forms of race-conscious policy, whether they're designed to segregate or desegregate, are subjected to the same skeptical level of review. If we think about Justice Roberts' opinion in Parents Involved in Community Schools, the famous line, what it means to stop discriminating on the basis of race is to stop discriminating on the basis of race, the kind of ultimate logical tautology. But the imposition of strict scrutiny on race-conscious affirmative action did not just come about under the sky. It came about following decades of political and legal attack that sought to reframe affirmative action as reverse discrimination. So this is not a fight only about legal interpretation. I want to make that clear. It's a political battle in which, in the realm of electoral politics, social meaning, and culture, what counts as racial discrimination was being contested. This has been the culmination of a period of what my colleague and Jerry's colleague Kim Crenshaw calls a period of retrenchment, in which the gains of the previous era have been under assault. Well, Proposition 209 really represented a new stage of that assault. As Tom pointed out, California law has prohibited discrimination for decades. Proposition 209 wasn't really about ending discrimination. It was about ending affirmative action. And the initial target was affirmative action, I want to argue, for some very good reasons. While today we think about affirmative action in the context of college admissions mostly, affirmative action actually arose, and I think someone talked about this earlier, as part of the fight of working class movements of people of color. That is to say, affirmative action was an intervention advanced by workers' organizations to challenge the racial, wealth, and social network preferences that were embedded in traditional selection criteria that constituted barriers to entry for working class people. Affirmative action actually came from below, although you would not necessarily know it in the stories that we tell today. If we think about the contest over union membership, over government contracting, this was really working organizations attacking the system at a place where it was vulnerable. That is the expenditure of government money for the construction of businesses and institutions. More broadly then, at the outset, affirmative action was really rejecting the notion that discrimination could only be proved by individual claims and could only be remedied by voluntary compliance. It was an attempt to press the system to actually reveal itself, to lift the hood on the selection processes and to say, exactly how is it come to pass that this particular workplace is predominantly white and male? What are the processes that led to this? Why do the candidates for particular positions have to have X, Y, and Z criteria? How are those criteria related to performances? Do the current occupants of the positions, and this is often a difficult one, do the current occupants of the positions meet the criteria that they are now imposing? So affirmative action in scrutinizing merit was exposing the race and class privilege that were built into these facially neutral policies. It was a mechanism to strictly scrutinize the claim that selection processes were functioning, that the way they were functioning was fair and neutral. So the affirmative action was not only potentially disruptive, but it was actually beginning to have redistributive effect. That is to say, race-conscious affirmative action was actually functioning to promote better conditions for segments of poor and working class people of color, and a vehicle for eliminating, certainly not totally, but for alleviating certain dimensions of class inequality. That said, it's notable that Proposition 209 refused to identify itself as an anti-affirmative action measure. If you recall, there was litigation over this question, and the proponents of affirmative action sought to force the proponents of the initiative to say what it is they were actually trying to do. Why was it that they were not willing to say what they were trying to do? Well, part of it had to do with engendering voter confusion, but there was also another ideological component of this fight, which was to reframe race-conscious intervention like affirmative action as a racial preference. What was at stake here in this reframing was facilitating the push to reframe affirmative action as a racial preference was largely successful, but it was represented an effort to gain new ground in an ideological battle. Why was this important? Because it was undergirding an argument about colorblindness as equal protection, colorblindness as being the opposite of race preference, colorblindness as being race neutral, when in fact what we know, colorblindness and so-called race-neutral processes are the principal way in which discrimination and subordination is reproduced right now. So we could think about it in the context of what we consider merit. Most of the traditional criteria that we consider for admissions, say for example in college admissions, disproportionately helps white elite students. And if in fact we think of that as producing a preference, those are the real racial preferences that we ought to have in our sights. Instead, the reframing of affirmative action was designed to basically redefine it as racial preference in a way that took our eyes away from the ball. And so now we have an opportunity today to actually rectify some of that. We have an opportunity today to actually undo some of the ideological harm that has been done that causes us to even question whether or not we are in favor of affirmative action. I don't know about some of you, but I've actually had conversations with people who want to reject it because they think of it as a racial preference. That is part of the battle that Proposition 209 was designed to win, and that is part of the battle that we must fight and win today. Thank you.
Well, thank you to all of our panelists. This is wonderful. All of you gave great insights and, covered a lot of different areas. It's like I had a list of questions for the panelists, but you all addressed almost all of them in one way or another. But we've also got great questions from the audience, and I want to encourage the audience to keep bringing in the questions in the Q&A. We won't be able to get to all of them. There's a lot of them. I'll try to kind of fold them together and fold them with some of my own questions also. And any of the panelists can feel free to address these questions. I'll kind of let that go. I'll let you kind of, speak and then the next person speak. If there's a need to really moderate that, I will. But I think you all will be able to have a nice conversation. So the first question I want to ask, and it's really a couple different questions folded together, partly mine, partly from the audience. There was a question about why we can't just use socioeconomic status, income, wealth, some measure like that, rather than using race. And, I'll kind of add to that, you look at affirmative action in university admissions, it seems to be a battle about elite universities. A majority of institutions of higher education have open admissions. And people say, doesn't affirmative action university admissions just really benefit the most privileged people of color? People of color who are coming from, rich families already. They're the ones who benefit from this. You have institutions like Harvard that are involved in these lawsuits. So are people of color who are less privileged kind of being missed in this whole affirmative action debate? Oh, Eva, you're muted.
People have used class as a basis for admissions, but it turns out white people are overrepresented in that group as well. So it doesn't really get at the racial issue. I was admitted to Berkeley Law School in 1972 under affirmative action. I'm not from any rich family. My dad was in the military service in the Air Force for years, and I'm a working class person. 4 years before, I had been at Northwestern University that had a lot of, that had never had a lot of Black students. And the university decided that they wanted to bring in Black students, and they were from the South Side and West Side of Chicago. These were not elite kids. But I would say that to me, affirmative action is a desegregation tool as well. And if there are rich white people at Berkeley Law, why not have rich Latinos at Berkeley Law? So those arguments don't really work from my perspective.
I'd like to add on to what Eva suggests here. I think to some degree, the class question is a red herring in this respect. Not that there are not class privileges built into the entire system of higher education. They are, not just in the institutions that practice affirmative action explicitly, but those that don't. The entire system is rigged in a particular way, rigged against working class people and rigged against people of color. So class is highly relevant in that way. But in the context of this debate, it's often a red herring, and it's proceeding under kind of contradictory premises. The premises are that if you address class inequality, you will somehow capture race inequality. At the same time, the critique of race-conscious affirmative action says, well, if you address race inequality, you will fail to address class inequality. Both of those things cannot be true. In some respects, what I'm suggesting is race and class in this country have always been mutually constitutive, but they are not always symmetrically aligned. That is to say, one can think about a circumstance where an intervention on the basis of race will have some ameliorative effect with respect to class, as well as thinking about some intervention with respect to class that will have some ameliorative effect with regard to race. But those things are not co-constituent. They are not always equal. They are not always similarly positioned. And the idea that race-conscious remediation never addresses class inequality, or that class-based interventions always address racial inequality, both of these are wrong.
So if I could just add, I first want to say it's easy to think that this is really about Berkeley and UCLA, even in the context of higher education. But the truth is, in California, it isn't. And that is because we have underinvested and continue to underinvest in our public institutions of higher education, with the effect of rendering admission in the last 10 years to Cal State campuses and Cal State majors selective. So the Cal State campuses and majors are now replicating the problems with selective admissions at the University of California. They're using bias criteria with no demonstrable connection to success, like standardized test scores, and overweighting them, just as we've seen in the more stereotypical selective institutions. So this is no longer just about Berkeley and UCLA in the state of California. Because of underinvestment, it's about the California State University system as well. And I'll just expand upon what you've already heard. The fact is that class-based approaches are incomplete. And the reason is that there remain race-grounded effects and race-based discrimination in our country. If anything, we're living in an era where that's even more obvious. As I was explaining to a reporter the other day, when Donald Trump calls it the Chinese flu or Kung flu, that's not about class. That's clearly about race, and it's clearly about affecting people's thinking in a race-based way. And that has impacts. Similarly, when he began his campaign in June 2015 with a slander against all Mexican immigrants as rapists and killers, and then doubled down a year later calling a federal judge biased against him because he's Mexican American, that's not about class. That's about race, and that's designed and has had an effect on people's behavior, including people who are in decision-making positions who are then more affected by subconscious bias based on race, not on class, that plays out in their decision-making. And that's why we have to have all of the tools at our disposal as Prop 16 would make available.
Can I just quickly say as a soundbite, look, sometimes you need a spoon, sometimes you need a fork. Yes, you can use a fork to get like soup out of a bowl, I get it, but it turns out a fork is more efficient for certain things. Race and class overlap, they're not the same. I'm plenty wealthy right now because I've worked hard and succeeded, whatever. Doesn't mean that I can't be actually mocked for wearing a mask in a particular kind of way or that I have the same opportunities. It is what it is. So why hamper ourselves, right? It's not spoon or fork. It's not always spoon. It's spoon and fork. What's the problem?
Anyone else? Okay. A number of questions coming from the audience. So again, I'm trying to fold them together. I got a question about intersectional approaches, intersectionality and affirmative action. Probably a couple of questions about, how does affirmative action, say, affect people with disabilities? But, the discussion, the debate here is really seems to be focused on race. That's where the legal attacks are coming. That's where the political discussion is. How does affirmative action go, I don't want to say beyond race, but how does it intersect with gender, disability, LGBT, sexual orientation, other kind of marginalized statuses, and how is that playing into the whole discussion on Prop 16, if at all?
Well, I'm sorry, go ahead, Cesar.
Thank you, Professor. I'd be happy to get us started and then pass it on to anybody else. I think one of the things that's really powerful when we saw this president get elected is seeing the power of the women's movement and the women's march that went national. And then we think about the resurgence of the Black Lives Matter movement. We think about immigrants' lives struggles, indigenous law struggles, API, Raza, and Latino communities standing up for their issues. I think that when we think about affirmative action and we think about the power of intersectionality, it is key. And as you see it on this panel, we spoke about different issues. We talked about Asian Americans. We talked about Chicanos and Latinos. We talked about African Americans. And so I think it's critically important that we unite our struggles when we are able to and understand our collective power, because a lot of these systems and structures that have been set up to oppress us, they've oppressed us all, and we're not here to play oppression Olympics, but rather unite as people and fight for our collective rights. And so my humble suggestion is that we continue to look across our struggles and see what we have in common and be able to stand up together for our rights.
So I'd just like to say, again, for purposes of this campaign, we are repealing a measure that was drafted by others. So of necessity, because we're talking about a measure in Prop 209 that focused on race and gender, that's where the debate focuses. But the truth is that if we pass Proposition 16, we will enable policymakers to engage in the deep and thorough analysis that's a requirement before you implement affirmative action, and that will help us to identify criteria for selection, whether in education or employment or contracting, that have inappropriate discriminatory effects on anyone. The best example of that to me is the use of standardized tests in higher education admissions. When we do the deep analysis about what is causing some of the disparities in admissions that we see and recognize that it's overweighting or even using standardized test scores, and we recognize that those standardized test scores don't correlate with success in universities, we will eliminate them. UC has taken halting steps toward doing that, but it's taken how many years to get there? But if we do that kind of regular analysis, we'll root out those criteria that are unfair to anyone because they're simply not related to what we're making selections for. So when we eliminate standardized test scores, people across the board will benefit from that. White men who are right now not good test takers and are facing a barrier because of the use of standardized tests, white men will benefit from enabling the kind of consideration that Prop 16 would much more invite.
To just build on Tom's comments, I guess I want to say that part of the discussion we were just having about race and class is actually a call for an intersectional analysis. It's called for understanding the relationship between these as social categories and political realities. The further point is to say is that racisms actually operate as kind of differentially articulated technologies across groups. That's a big mouth way of saying that racism is operating in ways that support white supremacy, but that travel through time and peoples differentially. If we understand that, and actually understand the ways in which, for example, how race and gender play itself out differently in Asian American communities than they do in Black communities, than they do in indigenous communities. That is to say, the mechanisms actually function and operate in different ways. What we can get to is actually precisely what Tom was just talking about, which is if we actually drill down on the ways in which race and gender are operating, we're going to lift the lid on the ways in which these processes are actually unfair to lots of people. This was a point that Derek Bell made some years ago in his analysis of a case, United Steelworkers versus Weber, in which Weber, who was a white worker, challenged an affirmative action program that had been won by Black steelworkers. And he said, basically, I have more seniority than the people that were selected for the affirmative action program. As Bell pointed out, that particular point was true, but Weber would never have been selected for the position under the prior regime because they have a system that would not have allowed him to get into it. So there was no possibility for him to get in under the previous criteria, let alone challenge or I guess I should say shine a light on what the actual criteria were. It was the affirmative action policy that required the company to start to say how they were making these selection processes overall. So, yeah.
A couple of comments. You were just seeing a snapshot of us today, but we in our day jobs are doing lots of different things that involve coalition building. I think about Bayard Rustin, who's a gay man who wrote a lot of Dr. King's speeches. He wrote about something called the Grand Coalition. And the idea was that most of us have this vision of a better world, and we're responsible for little pieces of it, but we are all like an army, sorry to use militaristic metaphors, but we're like an army moving towards this vision, and we support each other. So if you look at the 500 groups and organizations that are behind Proposition 16, it's everybody. It's intersectionality on, I was going to say steroids, but that's not a good thing to talk about this week. It's intense intersectionality. And so we're asking all groups to come behind us on this, but then we're behind other groups that are not necessarily, we work on LGBT issues, on race issues, we work on everything, but the whole civil rights community has come behind us on this. Even like the Chambers of Commerce, we have some very strange supporters. All the male sports teams in the Bay Area have endorsed Proposition 16. That's some real intersectionality. So,
okay, what else? So again, trying to fold together a number of different questions. We had a few questions, comments about more specifically about Asian Americans and affirmative action. I know Jerry addressed some of this, but how different groups of Asian Americans are affected. But I think that question could be asked a little more broadly about, say, within group diversity. There's a lot of diversity among African Americans, among Latino, Latina, a lot of different communities within the rubric of Latino, Latina. How does that play into the political dynamic here around Prop 209 and around affirmative action? The fact that we have these this real within group diversity.
Yeah. Hey, if I can just start the conversation, I always make clear to people that, look, whenever you try to understand the world, oftentimes averages matter, but also the spread within any average. So even if you think that men are on average taller than women by a couple inches, the spread actually matters. If the spread is actually very large across those averages, you'll have plenty of women who are taller than men and plenty of, and vice versa. So what I'm trying to say is when we say, oh, Asians are the model minority, it could mean they're rich, it could mean that they're highly assimilated, it could mean that they test really well, whatever you want to pick. Even if you show some average differences, right? Putting aside like the various social forces that might drive it, just recognizing that there's a real spread around that and you can never understand the people by one number is really important. And that spread is not random. There are differences in averages between, say, East Asian populations, right? So South Asian populations, Southeast Asian populations that came post-75 as principally refugees after the kind of the wars that we participated in that part of the globe. There are lots of differences. And if you only look at the average, or if you look at only the most popular ones, then you forget everyone else. And by thinking that somehow Asians have it easy and they're always going to be, you forget the plight and the realities of Southeast Asian groups or Filipino groups that might look very different, at least on these metrics of academic, standard achievements. And that's the kind of sensitivity we need all around. So let's just be smarter as we disagree about things instead of using crude averages when we have to also appreciate the spread.
Cesar,
I think for every single racial and ethnic group, we have a duty to look within. When I think about the Latino community in California, and we don't talk about mom-speaking Guatemalan folks, thinking about, the danger of a single story, of a single narrative of the Latino people. What about refugees? What about immigrants? What about Central Americans from different countries? What about the undocumented? What about Afro-Latinos? And so as we unpack what it means to be Latino in California, yes, we're looking at ethnicity, we're looking at race, we're looking at socioeconomic statuses, we're looking at languages, we're looking at citizenship. And so I think it's our duty within all of our communities, especially those that tend to start to go into the middle class, whether it's African American, Asian American, Native American, Chicano, Latino, is for us to really see who's missing from the conversation. When we mentioned that 27% of our voting electorate are Latinos, who are those Latinos? Who are the Latinos that are making it, and where are the vast majority that are not? And what is it our role to be our community's keeper, to be able to lift all of our communities up in that important way? And so I think it's really important for every single community to look within, not just I and my family made it and somehow we're now part of some middle class, but what does it mean when they always tell us disaggregate the data and see who is being successful and who is not? And it's important that we not, I hate to use one of our former president's terms, that we not leave anyone behind.
And can I just interrupt just one little point on this? But it's also true for white people. And I want to just reach out to the folks who say, like, you say that about folks of color, but what about white folks? We got dirt poor white folks who are suffering like you wouldn't believe it, and you seem not to care. And I guess what I'm trying to say is, in the class and race conversation, we do care. We're humans of goodwill who want to increase opportunity for all. We do care. It's not either or, though. That's our point.
So if I could just extend off of what was said, I do want to point out that I've talked about what the Supreme Court requires to consider affirmative action, as has Professor Harris. But there are plenty of flaws with how the Supreme Court has addressed these issues. And certainly one of them is in recognizing solely diversity as the compelling interest for higher education affirmative action. that results, for example, in it not being an accident that the right wing chooses Texas in the Fisher cases to challenge affirmative action in higher education. They did that strategically because of the Latino community's size in the state of Texas, which matches what it is in California. So they could then point at the 20 to 25% of the University of Texas at Austin and say that's enough Latinos for diversity, and you can no longer justify an affirmative action program that considers Latinos. I will just digress to say that's also a lot of what's behind Proposition 209. I mentioned it being grounded in demographic fear, and it is quite clear in the public statements of Ward Connerly following the enactment of Proposition 209 that he is positively obsessed with the growth of the Mexican immigrant and Mexican American community. He boils down the Latino community just to those of the largest components of it alone, but he's obsessed with the growth of those communities, our communities. So it's replicated here in California, but it's no accident that they use Texas. So I have real problems with diversity as the only accepted compelling government interest. But what I will say is true diversity means exactly what my colleagues have said. It means going down, drilling deeper into the characteristics of people within each of these groups, and recognizing that diversity doesn't mean you can look at the 20 to 25% who are Latino and say that's it. It means you have to do a deeper analysis of who's represented in that 20 to 25%. I'll hasten to point out, as I did with respect to California, that 20 to 25% is still half the percentage of Latinos in Texas high schools, which is above 50%. So the problem with diversity is we don't get to address those underlying, continuing discriminatory disparities fully, but it also invites us to be more sophisticated about what diversity means within each of these racial ethnic communities.
Iva.
One of the things that I find so interesting in talking about race is that we're often saying, white people, you need to get yourself together. But I was kind of brought up short when I was talking to a group that Cheryl and Jerry may know about, the Black Labor and Community and Clergy group in LA. And I was talking away about, affirmative action and contracts and UC Berkeley. And one brother said, you're not speaking to me at all. You're not speaking about a brother who wants a job with government. We don't care about contracts or UC Berkeley. And I was really brought up short. And I think that's what Cesar and Cheryl reminded me of when we're talking about this. We have this very interesting group in the Black community called the Boule. It's all very upper class Black men, and they've never taken a political stand on anything. They're really into this, and that's delightful. But I was really given a wake-up call. This is not just about elite Black folks. So it's an important point to bring up.
Okay. I might ask a kind of combined legal, social, activist questions. Again, trying to combine some different thoughts, different questions here. So one of the, we've had a few questions about, kind of the discord between what's going to happen in California and nationally. Even if Prop 16 succeeds, isn't the Supreme Court going to strike down affirmative action given its current composition? Wouldn't Prop 16 itself be challenged? So, is this all for naught in a sense? And, that's kind of a legal question. Is there anything legal that can be done to save Proposition 16 if it passes in the long run? And even if not, what is the benefit of organizing in this way? Why is it still important to try to do this, even if we think the Supreme Court is going to strike it all down soon?
I'll try that one because I think that's exactly where I tried to begin.
Mm-hmm.
2 points. One is on the specific question is, will Prop 16 be challenged? Probably, because everything is, regardless of whether or not there's actually a legitimate, cognizable legal claim. That's just the way they roll. That's how they've gotten the wins that they've gotten. They swing for the fences, and whether or not there's actually a legal basis, I don't know, Tom, you may disagree, but my prediction is they'll try to find some way to challenge it. I think under existing law, as I understand it, though Proposition 16 does not mandate the consideration of race and gender, it permits it. And so that would then take it under the question of whether or not the programs that are developed pursuant to Proposition 16 can pass through that test that I talked about at the beginning, that strict scrutiny test. Because Tom litigates this stuff all the time, I'm going to defer to him on the ultimate answer to that question. But I guess I will just say, the question as I understand it is, given the fact that we are pushing uphill against a big doctrinal barrier, and as I mentioned before, with the passage of Ginsburg and the attempted replacement of her with Amy Coney Barrett, the likelihood that the votes for affirmative action there are simply not there. I think we cannot only determine what our course of action is based upon what we predict the particular outcome is of any legal battle. I think in this regard, we have to think about and look at the ways in which certain kinds of doctrinal changes are brought about over time. If I think about, for example, what the nature was of Second Amendment doctrine when I was in law school, which was pretty much the idea that there was no individual right to bear arms, and now look at where it is now, that didn't just happen overnight. That happened as a consequence of a concerted campaign to change the law, as well as to change the federal courts, those two things having to go hand in hand. But my point is to say, sometimes in the context of even recognizing that that one may be in a precarious position legally, that does not mean that there is not value in fighting that fight. What I was trying to say is, it's about a war of ideas. It's about fighting for a redefinition of what we consider racial discrimination to be. We are about to probably sail into a period where the law, as it comes out of the Supreme Court, is going to bear very little resemblance to reality. That is, it already does, but that distance is likely to increase. Now, what kind of politics can we enact in our own way to resist that and to actually heighten and illustrate that contradiction? Will that result in some kind of effort to reshape the court? I don't know. All I can tell you is that when we are thinking about these battles, we cannot think about it in transactional terms. We cannot think about it in terms of, do we win this particular fight today? Because what we're fighting for is we're fighting for the ground to fight tomorrow. And that's absolutely one of the reasons why I think it is of value.
Anyone else?
I would just say, reiterating that, this is about changing a policy mindset away from where it's been unfortunately stagnated for a quarter century. And I think changing that policy mindset with a focus on disparities and what do you do to root them out, that survives whatever the U.S. Supreme Court does. And in fact, I want California to be in a position to be a counterweight, as Professor Harris has described, when we face that. And I want California to be in the lead in coming up with what are the alternative approaches or the challenges that are going to change a national mindset that may be put in a different direction by what the U.S. Supreme Court does. And with respect to the other question, yes, there is likely to be a facial challenge to Prop 16. I think it is very unlikely to succeed. As Professor Harris said, this is a matter of eliminating a prohibition. So until somebody actually takes up the invitation, it really doesn't have any effects that you could challenge. We do have to be careful, and Iva's organization is working very carefully to make sure that folks have what they need to implement this in a constitutional manner. So we got to watch out for the challenges as this is implemented by agency as they go along. And the only other thing I'll say is, yes, there will be a challenge to the face of it, but we should not be afraid of that. We've seen crazy such challenges from the right before. All that just came out of a challenge to the California Voting Rights Act, the statute that just facilitates transitioning from being at large in your elections to districted. And that was challenged as reverse discrimination. So yeah, we'll see it. It won't go anywhere, but we got to be careful about implementation.
Eva.
Couple of quick things. We've already had a meeting about the challenge. We're sure they're going to file a suit the next day. The Attorney General defends it, and Becerra is with us. We're also talking about intervening on behalf of the real people and interest. I keep this picture, you probably can't see it, of Harriet Tubman beside me all the time. She was told slavery will never end. Why are you even wasting your time? And Cheryl alluded to this, who knows what the Supreme Court's going to look like in terms of composition in a few years. And agencies are already making changes based on their thought that Proposition 16 will pass. People have, minority businesses have shown me RFPs, requests for proposals, that specifically talk about race and gender. One of the constitutional officers of the state of California sent out a proposal to a woman of color saying, I know Proposition 16 is going to pass. She has never been asked to be a prime contractor ever. So things are changing. And we've been told by the campaign not to mention that the Supreme Court may overturn this. So I'm going to blame it on you. But there'll be like a window where this will be in effect, and we'll get everything through that we can and just wait. We're just going to keep fighting.
Jerry, do you want to? Okay, Cesar. Okay. Yeah, we are out of time. I want to thank all of the panelists. This is a great discussion, great conversation, and hopefully California can get this thing passed. But thank you to everyone.
Vote.